We now have the Office of the Commissioner of Insurance presenting, or two people from the Office of the Commissioner of Insurance, excuse me. We have Sharone, who is a health insurance attorney with the Office of the Commissioner of Insurance, and she has been with them for 3 years. She is an attorney with experience in health law, healthcare finance, clinic management, and healthcare advocacy and outreach. We also have Shelly, who has been with OCI for 7 years and within the insurance industry for 30 years. Prior to coming to OCI, she was a property and casualty underwriter for QBE Insurance. I will go ahead and hand it over to Sharone and Shelly.
Good morning. As Elizabeth said, my name is Shelly. I'm with the Office of the Commissioner of Insurance. And the first presentation we are giving here this morning is simply called Introduction to Insurance. Next slide, please. The Office of the Commissioner of Insurance was created by the state legislature in 1870. It continues its work today, making sure that the insurance industry meets the insurance needs of Wisconsin's citizens. Next slide, please. OCI's mission has both a consumer component and a company component. In addition to helping consumers navigate the insurance marketplace, we also ensure companies are healthy from a financial perspective in terms of having reliable, compliant business practices. This helps ensure that Wisconsin consumers continue to have plenty of dependable choices. Next slide, please. We serve as a resource for consumers, insurers, and agents on a practical level. We also monitor market activity for misleading or deceptive practices. We help consumers connect with resources for help in making new enrollment choices, and will investigate consumer complaints to ensure that substantiated complaints are referred to our legal unit for possible administrative action. Next slide, please. These numbers on the slide are from our insurance report released in 2024. Unfortunately, we didn't have the most recent report available until after these slides were finalized. In 2023, there were 2,058 insurers authorized to write business in Wisconsin, with 316 of those domiciled in Wisconsin. There are over 219,000 agents licensed to do business in Wisconsin, and over 33,000 of those are Wisconsin residents. In 2023, OCI investigated and resolved 3,117 written consumer complaints and handled over 21,000 general inquiries received via email and/or telephone. OCI assisted complainants in recovering over $6 million from licensed entities. Next slide, please. The powers and duties of the insurance commissioner are to protect and educate the public, and to ensure that the insurance industry meets the needs responsibly, adequately, and even-handedly. Next slide, please. The commissioner shall administer and enforce the insurance chapters and shall have all powers specially granted or reasonably implied to enable the commissioner to perform the duties to administer and enforce the statutes and regulations. Those considered doing the business of insurance are regulated and required to have a certificate or license. Also, the commissioner is granted the authority to require responses of licensees. The commissioner has the authority to require from any person subject to Wisconsin regulation under the law, such as agents, insurers, navigators, and agencies, the following: statements, reports, answers to questionnaires, and any other information in whatever reasonable form the commissioner designates, and at such reasonable intervals as the Commissioner may choose, and a full explanation of the programming of data processing systems, computer systems, and any other information storage system or communication system in use. The Commissioner may recommend forms for the reports and specify who must execute or certify them. The Commissioner may require verification of any report. Lastly, the Insurance Security Fund was established to provide certain protections to insureds in the event of an insurer's liquidation. Money in the fund comes from assessments against all insurers, with some limited exceptions, who are licensed to transact business in the state. This fund is administered by a board of directors to include the Attorney General, the State Treasurer, and the Commissioner of Insurance. Next slide, please. The Commissioner is granted broad authority to regulate the insurance industry by balancing consumers, insurers, and legislative requirements. The legislative note to the introductory section of the insurance statute states, insurance is an area of free contractual activity, except as restricted by the insurance code. This freedom to contract allows a free marketplace and the responsibility of OCI to monitor the marketplace to maintain a level playing field. Next slide, please. There are three key pieces to this specific statute: the balanced solvency of insurers, the fair and equitable treatment of insureds, and legislative direction and oversight. To have the ability for freedom of contract and freedom of enterprise requires a level playing field and accessible and understandable contract terms. The purpose of this is to provide for an office that is an expert in the field of insurance and has the authority to enforce chapters 600 to 655 of the Wisconsin statutes, to encourage full cooperation of the office with other regulatory bodies, both of this and other states and of the federal government, to improve and thereby preserve state regulation of insurance, to encourage self-regulation of the insurance enterprise, and to encourage loss prevention as an aspect of the operation of the insurance enterprise. Next slide, please. Enforcement by state agencies is conducted through administrative proceedings. A neutral judge hears the facts and evidence and renders a preliminary decision, with the final decision issued by the Commissioner. Because the Commissioner is the final adjudicator, they are walled off from matters that may be contested. However, they are fully engaged. Whenever a person fails to comply with an insurance law, regulation, or order, the Commissioner may start a legal action directing the person to comply with the Commissioner's order and restraining that person from further noncompliance. In addition, forfeitures, license revocation, suspensions, civil penalties, and criminal sanctions may be imposed by the Commissioner. The Commissioner must hold a hearing before issuing a rule or order whenever the insurance laws or the administrative procedure requirements expressly provide for a hearing. Unless the insurance laws prescribe special procedures, all hearings must comply with the procedures set out in Chapter 227 of the Wisconsin statute and Chapter 5 of the Wisconsin Administrative Code. The statutes do also provide for the summary suspension of an intermediary's or navigator's license if the Commissioner finds that public health, safety, and welfare require such emergency action. If the intermediary or navigator fails to pay a fee when due or fails to comply with continuing education requirements, the Commissioner may revoke the license without a hearing. Also, a license must be revoked if the intermediary or navigator is liable for delinquent taxes or unemployment insurance contributions as certified to the Commissioner by the Wisconsin Department of Revenue or the Wisconsin Department of Workforce Development. Next slide, please. One section within the Division of Market Regulation at OCI is agent licensing. The agent licensing division has four main parts: the licensing of insurance intermediaries, regulation of insurance marketing practices, compensation of insurance intermediaries, and the licensing and regulation of navigators and non-navigator assisters. The licensing of intermediaries and navigators is concerned solely with the qualifications of the person applying for the insurance license. The essential requirement is that they be trustworthy and competent. Competence includes a basic understanding of fundamental insurance law as well as knowledge concerning specific statutes and rules. Wisconsin insurance statutes outline and define the general requirements which the the insurance intermediary must follow. In addition, the insurance intermediary must understand and follow the administrative code which has been adopted by the Commissioner. General statutory language is expanded and clarified, describing for agents and companies the practices that are allowed and/or prohibited. These rules are strictly enforced by the Commissioner. Next slide, please. When is an insurance license required? Simply put, in most instances, a license is required when a person is doing the business of insurance. Persons may be exempt if the functions they perform do not require special competence or trustworthiness, or to achieve other purposes that are stated in Chapters 600 to 655 of the Wisconsin statutes. Regulatory surveillance is made possible by licensing. Next slide, please. Here are some scenarios in which a license may or may not be required. So number one, a person who incidentally advises other persons about insurance needs and coverages during the normal course of his or her non-insurance related business and who receives no direct or indirect compensation on account of any transaction which results from that advice. The answer to that one would be no. This person comes under the exceptions listed in Statute 628.02 and is not considered an intermediary. So how about a person who places insurance for an insurance company on a door-to-door basis? The answer to that would be yes. Under statute, again, 628.02, this person is an insurance marketing intermediary and is required to obtain a license. And lastly, a person who advises other persons about insurance needs and coverages and is directly compensated by an insurance company or the insured. And again, the answer to that is yes. Under statute 628.02, this person is also considered an insurance marketing intermediary and is required to obtain a license. Next slide, please. So what is the difference between an insurance agent and an insurance broker? The key difference between an insurance agent and an insurance broker lies in who they represent. Agents represent insurance companies, while brokers represent the client. Agents sell policies from a specific company they work for, while brokers can offer policies from multiple insurance companies. Next slide, please. So an insurance agent represents the insurance company they work for and are contracted by a specific insurance company. They have limited product selection as they can only offer policies from the company or companies that they represent. They can bind coverage, they can finalize the insurance sale and bind the policy. They may be captive or they could be independent. Captive agents work for one company, while independent agents represent multiple companies. Next slide, please. So an insurance broker represents the client. They work for the individual or business needing insurance. They have multiple product options that they can shop for policies from various insurance companies. They, as an advisory role, help clients assess their needs and recommend suitable policies. They have no binding authority. They cannot bind coverage and need to work with an agent or insurer to finalize a policy. And as far as a fiduciary duty, brokers have a legal and ethical obligation to act in their client's best interest. Next slide, please. The definition of risk relating to insurance is the uncertainty of a financial loss. The term risk tolerance is the amount of risk one is willing or wanting to take on by themselves or can afford to take on. Insurance is defined as a transference of risk. One pays a premium to the insurance company to take that financial risk from them to the company for a fee called a premium. Typically, the more risk you transfer to an insurer, the higher the premium is for the product, as the potential for loss is greater. Often, you will see lower premiums with group products. The reason for that is the law of large numbers or pooling of risks. The insurance agreement is a contract and is governed by contract laws. The basic elements of a contract are an offer of coverage, an acceptance of the coverage, consideration, which is also known as the money, and an intention to create a legal relationship. Once entered, a contract is enforceable. For example, you identified an insurer offering health insurance and you have selected from the available options to purchase. You reviewed the policy, also known as the contract, to ensure that after you pay any member cost sharing, the insurer will pay the remainder as defined under that contract. During the policy period, which is typically 1 year, you will look to the insurer to fulfill its obligation. Next slide, please. With regards to insurance contracts, the laws and regulations in our chapters apply to all insurance policies delivered or issued for delivery in the state for the following: persons residing in Wisconsin when the policy or group certificate is issued, property ordinarily located in Wisconsin, or business operations in Wisconsin. As far as the readability of policies, INS 6.07 establishes the minimum standards for legibility, coherence, and understandability in consumer insurance policies on a scale of 0 to 100. If it scores 100, it's easily understood by an average 11-year-old. But if it scores a 10, it is very difficult to read and best understood by university graduates, and there are many levels of understanding in between. Is a notice to an agent the notice to the insurance company? Yes. The insurance company has been notified if the company's authorized agent has been notified by or on behalf of a policyholder or insured and provided with sufficient information to identify the policy in question. Every insurer is bound by the acts of its agents performed in Wisconsin that is within the reasonable scope of the agent's authority. The insurance company remains bound while the agency contract is in force or until the insurance company has made reasonable efforts to recover the policy from the agent its policy forms and other documents from the agency. An insurance agency is deemed to know any material fact that to the risk that violates a condition of the policy. If the insurance company who transmitted the application to the insurer knew at the time that he or she acted, if afterwards any of the company's agents learned of the fact during the course of dealing with the policyholder as an agent and knew the fact pertained to the eligibility of the policy. Misrepresentation by an intermediary is the use of a written or oral statement which incorrectly describes the terms and or benefits of any policy. Representations are oral or written statements made by an applicant. Insurance coverage is issued based on the applicant's representations. A material misrepresentation is an untrue statement made by an applicant that would influence a prudent insurer in determining whether to accept the risk or in fixing the amount of premium in the event of such acceptance. Wisconsin consumers are provided with privacy protections for medical and financial information. These laws correspond with the requirements under the Federal Health Insurance Portability and Accountability Act, also known as HIPAA, and the Graham-Leach-Bliley Act, also known as GLB. Chapter INS 25 of the Administrative Code for Wisconsin addresses insurance agents' responsibilities when sharing consumer and customer private, personal, financial, and health disclosure information with third parties. Insurance agents may, for the most part, rely on the insurance companies with which they are listed to provide these notices and disclosures. Wisconsin also enacted a statute that regulates the disclosure of personal medical information. It places restrictions on both insurers and the persons that regularly assemble or collect medical information for the purpose of providing the personal medical information to the insurer for the determination of an individual's eligibility for health coverage, benefit, or payment, or for the servicing of an insurance application, policy, or certificate. This rule establishes restrictions on the sharing of health information. In addition to health information, Wisconsin enacted rules that require insurance companies and agents to provide written notice of its privacy policies and practices. The rule describes the conditions under which insurance companies and their agents may disclose non-public personal financial information. The rule also establishes requirements for privacy notices. And yes, there is the right to file a complaint with our office. Insurers are required to notify their insureds of the right to file a complaint with OCI regarding problems they may have with their insurance. The notice is required once for each policy or certificate issued by an insurer. Next slide, please. So we've come to our first polling question. So the question is, an insurance company is bound by the acts of its appointed agents when the agent acts within the scope of their apparent authority, even if they do not have actual authority from the company. So true or false? We'll give you about 20 seconds to respond. So we'll wrap that up. The answer is true. They are bound by the acts of their agents, as we just talked about in the previous slide. Next slide, please. So regarding the notice of claim, proof of loss is to be furnished to the insurer as soon as reasonably possible and within 1 year after the time it is required by the policy. An example of this would be submitting a prescription cost receipt in a timely manner for something you had to pick up while on vacation once you returned home. Regarding the prompt settlement of claims, under other, unless otherwise provided by Wisconsin law, subject to an interest payment, an insurer must promptly pay most insurance claims within 30 days of receipt. And as for a mistake, what is the legal effect of a mistake in an insurance contract? In most circumstances, unless otherwise provided, general contract law applies to mistakes in insurance contracts. For example, in a property insurance situation, a mistake is designating the person to whom the insurance is payable, but that does not void the policy. Such a mistake does not constitute a defense for the insurance company unless the mistake was due to misrepresentation or concealment by the owner of the property. Next slide, please. What are some examples of unfair claim settlement methods and practices? One would be the failure to promptly acknowledge pertinent communications with respect to claims arising under insurance policies. Another is the failure to promptly provide the necessary claim forms, instructions, and reasonable assistance to insureds and claimants. Another is the failure to attempt in good faith to effectuate fair and equitable settlements of claims in which liability has become reasonably clear. And lastly would be knowingly misrepresenting to claimants pertinent facts or policy provisions. Regarding the right to return a policy, each line of insurance has a period of time for which a consumer can return the policy without any penalty. Life insurance, for example, is 30 days after delivery for a full refund when the new policy sold is a replacement of an existing one. For health insurance, a policyholder may return any individual health policy within 10 days after receiving it. If the policyholder returns the policy within that 10-day period, the insurance contract is invalid and all payments made under the contract must be refunded. The right to return must be printed on or attached to the first page of each individual policy. For grace periods, although an insurer may cancel a policy for non-payment of premiums, a consumer is entitled to a grace period for the payment of any premium due. During this grace period, coverage does continue. Per state law for health insurance policies, it is not less than 7 days for weekly premium policies, not less than 10 days for monthly premium policies, and not less than 31 days for all other policies. A consumer should always check their policy to see if their insurers includes a grace policy provision. ACA plans will have different grace periods depending on whether or not the consumer is receiving the advanced premium tax credit or not. Next slide, please. And now I will turn this over to Sharone. Thank you.
Thanks, Shelly. Good morning, everyone. So we have a number of categories of companies or people that are generally exempt from OCI jurisdiction. The key word there is generally. The way our rules and statutes work, any person or company doing the business of insurance is subject to OCI jurisdiction unless they prove that an exception applies. The first two companies or plans on this list are self-funded employee welfare benefit plans operated by either employers or labor unions. Self-funded basically means that these are plans providing a variety of types of insurance, generally health and welfare, like medical, med supplement. And the self-funded part means that these plans are actually acting as the insurers and taking on that risk. So a lot of large employer groups will do this. They can take on their own risk, and then they work with an insurance company to do the administrative side of things. Next on this list are discount plans, which kind of obviously, as the name implies, are just discounts on things like medications. There's no transfer of risk in exchange for a premium, so this is not insurance. Medicare Advantage plans by federal law are regulated by the federal government. States retain jurisdiction to regulate agents, but we cannot regulate, for example, misrepresentation more generally in the sale of Med Advantage plans by the insurer. Medicare Part D, these are prescription drug plans that are sold separately from Medicare supplemental insurance or traditional A and B coverage, kind of for the same reason as Med Advantage plans. We are preempted by federal law from directly regulating Part D plans. Healthcare sharing ministries are essentially kind of the original form of a GoFundMe account. These are plans in which members voluntarily get together. They're of the sort of same religious denomination, and they agree to share their medical needs with that community. It's not insurance because there's no agreement to pay. And so it is generally outside of our jurisdiction. A note on this, there are many healthcare sharing ministries that might actually fall under a jurisdiction because we have very specific criteria that a healthcare sharing ministry has to meet under Wisconsin law before they are exempt. Lastly, direct primary care is typically primary care providers or internists, family practitioners that negotiate directly with consumers. If there is a component of risk transfer, then OCI might retain jurisdiction. But if it's truly a situation in which people are sort of prepaying for primary care, then we would tend not to have jurisdiction. Next slide, please. Now I'll run through some insurance products that are regulated by OCI, but that are not considered major medical, traditional health insurance, or ACA compliant insurance. First, we have fixed or limited indemnity plans, which kind of goes together with AD&D plans, accidental death and dismemberment. Essentially, these are plans that will pay out a fixed amount in the case of a covered event, such as for AD&D, an accident, or for limited fixed indemnity plans, an overnight hospital stay, certain procedures, something like that. These plans do not provide coverage for essential health benefits. They can exclude pre-existing conditions and have annual and lifetime benefit limits. And most clearly, these plans are not major medical because they only pay a fixed amount of total charges, say $500 overnight in a hospital. Next slide, please. So here are some of the key practices that OCI monitors. Unfair marketing practices. The big one here is misrepresentation, but we also look at restraint of competition, like anti-competitive practices, and preventing people from picking their insurer. Misrepresentation can include misleading statements and also misleading omissions. Restraint of competition are things like boycotts, intimidation, and choice of insurer includes requiring a purchase of insurance as a condition of contract not relating to insurance. We also look at home solicitation and sales to make sure that there's a clear statement on the intent to sell insurance as part of that visit. Next slide, please. When it comes to health insurance, prospective buyers must be provided with clear and unmistakable statements, explanations, advertisements, and written proposals concerning the policies offered to them. This includes printed and published material, including the internet web pages, social media pages, descriptive literature, and sales aids of all kinds, and prepared sales talks, presentations more generally. Advertisements and representations must be truthful and not misleading, and must accurately describe the policy that they're talking about. And an advertisement generally means printed as well as oral representations. Advertisements also may not directly or indirectly make unfair or incomplete comparisons of policies or benefits. And lastly, advertisements may not falsely or unfairly disparage, discredit, or criticize competitors or competitors' policies, services, or business practices. Next slide, please. OCI has staff looking at websites, media posts, and mailings, and we will respond to complaints on any of these issues. For phone calls and applications taken by phone, if the application was taken over the phone by an intermediary, we have a rule that specifically requires the agent to keep the application for 3 years. This is considered a record, even if it is taken over the phone or conducted online. For e-delivery, if an oral communication or recording of an oral communication can be restored and reproduced, then the oral communication may qualify as a notice or document delivered by electronic means. Companies are required to file forms with us, and the definition of form includes an application, and insurers must keep copies of these forms. If a company didn't file an application with OCI as a form, they cannot rescind the policy for material misrepresentation on the application. And for electronic and online applications, we view the screen as a type of form, and we would expect to be able to review that form. Next slide, please. Polling slide number 2. Which of the following types of insurance is generally exempt from OCI jurisdiction? A, healthcare sharing ministries. B, self-funded ERISA plans. C, Medicare Advantage plans. Or D, all of the above. We'll wait a couple more minutes or seconds. And the answer is D, all of the above. Next slide, please. Here are some common federal laws impacting health insurance. Medicare is a broad program of health insurance designed to assist the nation's elderly to meet hospital, medical, and other health costs. Medicare is available to most individuals 65 years of age or older. The Employee Retirement Income Security Act of 1974, also known as ERISA, is a federal law that sets minimum standards for most voluntarily established retirement and health plans in private industry to provide protection for individuals in those plans. COBRA gives workers and their families who lose their health benefits the right to continue group health coverage provided by the group for a limited period under certain circumstances, such as job loss, reduction in hours, transition between jobs, or other life events. Qualified individuals are required, however, to pay the entire premium for coverage. The Mothers Health Protection Act, Newborns Act, includes important protection for mothers and their newborn children regarding the length of the hospital stay following childbirth. This requires group health plans that offer maternity coverage to pay for at least a 48-hour hospital stay following childbirth, or 96 hours in the case of C-section. The Women's Health and Cancer Rights Act of 1998 is a federal law that provides protections to patients who choose to have breast reconstruction in connection with a mastectomy. This law applies generally both to persons covered under group health plans and persons with individual health insurance coverage. HIPAA was developed in 1996 and became part of the Social Security Act. It sets national standards to protect individuals' medical records and other personal health information. It gives patients more control over their health information, and it sets boundaries on the use and release of health records. I always pronounce this wrong. MPIA protects group health plans that offer mental health benefits from imposing more restrictive annual or lifetime limits on spending for mental illness than is imposed on coverage for physical illness. The Affordable Care Act ensures that all Americans have access to quality health care that is affordable. It eliminated the pre-existing clause that prohibited some consumers from being able to purchase a quality health care plan. And lastly, the Federal No Surprises Act was effective for services received after January 1st, 2022. This protects consumers from surprise bills for emergency services from an out-of-network provider or facility and without prior authorization. Out-of-network cost sharing, like out-of-network co-insurance or co-payments for all emergency, and some non-emergency services. It protects consumers from those costs. It also provides protections of out-of-network charges and balance bills for supplemental care, like radiology or anesthesiology, by out-of-network providers that work at an in-network facility. Next slide, please. Medicare is a federally funded and regulated program under the U.S. Department of Health and Human Services. It's available to most individuals 65 years of age or older, and some other people, like people with end-stage renal disease. There's also Wisconsin is an exempt state from the federal Medicare supplement products, which I will explain further on the next slide. Next slide, please. Medicare has 4 different parts, A, B, C, and D. Policyholders can stay with original Medicare, parts A and B, or purchase Med Advantage, part C, and most people also buy drug insurance, part D. Medicare Supplement, or Medigap, is a separate insurance product that's regulated by states. And Wisconsin is an exempt state from the federal supplemental uniform product offerings, which are generally associated with alphanumeric identifiers. So Wisconsin is a waived state, which means we provide a different kind of Medicare supplement policy, not labeled with letters. Medicare supplement policies in Wisconsin have set minimum comprehensive requirements for supplemental coverage. Individuals have 6 or 7 rider options available that must be separately priced from the base coverage. Some examples of these riders are foreign travel, Medicare excess coverage, and inpatient deductible coverage. If a consumer comes to you stating that they are being quoted a supplemental plan with a letter name, advise them to make sure that this is a Wisconsin plan being quoted and not one based in another state. Insurance companies sell policies referred to as Medicare supplement policies to fill coverage gaps left by Medicare. Medicare was never intended to pay 100% of a person's medical bills, but was created to offset medical expenses by providing basic benefits. Medicare requires a person to pay deductibles, and many Part B expenses are paid at 80% of the Medicare approved amount. Next slide, please. Insurance companies have the right to ask for additional information or documentation to help adjudicate a claim. Consumers may need to become involved with the process of assisting in obtaining this information from their provider if there seems to be a disconnect between the company and that provider. Next slide, please. Non-renewal of a policy refers to the termination of a policy at the expiration date. If an insurer decides it does not want to renew your policy, then there are certain protocols that it must follow, including mailing or delivering a non-renewal notice at least 60 days before the policy expires. The non-renewal notice must be clear and concise. It can't use general terms, and it must explain the reason for non-renewal. Next slide, please. This slide pertains specifically to midterm cancellations. Nothing is official until a consumer has been given 10 days notice. Notice could be provided by email, assuming that there is language in the policy informing an insured of this, and the insured has agreed to this method ahead of time. The Wisconsin Court of Appeals has ruled that when using the Postal Service to mail a cancellation notice, the written notice to the policyholder refers not to receipt by the policyholder, to the date the notice was mailed by first-class mail. Next slide, please. Here's generally a list of some scams currently targeting Wisconsin consumers. High-pressure sales tactics across the board, or a lot of double talk. Products that have the appearance of ACA compliant insurance, but aren't. We talked about this a little bit earlier, but short-term limited duration plans might be mismarketed as ACA compliant insurance. Or companies like healthcare sharing ministries might use their products to mimic health insurance. Next slide, please. Consumers searching the internet for health insurance, Obamacare, Marketplace might be directed to websites enticing them to enter contact information to receive rates. This would be considered misleading if it mimics healthcare.gov or informs people that they're signing up on healthcare.gov. Unauthorized use of logos of well-known companies might give an illusion of legitimacy and lead the customer to believe that they will receive information on coverage with these carriers. Next slide, please. Social media we see a number of misleading posts and ads, such as this one that says, just passed, the state of Wisconsin has recently improved new self-employed health insurance programs designed specifically for small business owners and self-employed, and it features our governor. This is not true. And text that falsely or misleadingly reference the state of Wisconsin or new insurance programs, that would be considered a misleading advertisement. Next slide, please. Here are some general tips for helping a consumer who may be scammed or who has already fallen for a scam. Help people spot red flags if you can, and try to refer people directly to healthcare.gov. And if you see something, say something. File a complaint with OCI. Anyone can file a complaint. We will either investigate it ourselves or refer to the appropriate agency if it's outside our jurisdiction. And when you file a complaint, just try to give us as much information as possible so that we can do the best investigation. Also, most policies have a free look-back period. So that this can be a way to get out of a policy if the consumer sort of immediately realizes that they've been scammed. Next slide, please. So anyone has the right to file a complaint with our office, and insurers must notify people of that right. Next slide, please. So a complaint is a dissatisfaction that anyone is having with a regulated entity, usually an insurance company, insurance agent, or some other regulated entities like PBMs. You can file a complaint with us if you're unable to resolve a dispute on our own. However, it is a public record, which doesn't usually affect most people, but it is something that might be shared with the redaction of things like personally identifiable health information. And electronic forms are available on our website to submit directly to our office. Next slide, please. So our health insurance examiners will kind of look at these types of questions and when reviewing a complaint, and when reviewing the responses that the insurer and or agent gives to the complaint, such as did the company identify the problem, make the consumer whole, was corrective action taken if the issue is with an agent. At OCI, we want the problem resolved within the guidelines of insurance laws and statutes. We do not want to see the problem continue, and we want to make sure that the customer is not harmed or wronged. So these are some general categories of remedies that we're looking for. Next slide, please. So what we will do, I kind of alluded to this, but when we get the complaint, we will send it out to basically the affected parties, like the insurance company, agent, review those responses. And then moving from there, we will work with the company and other actors and the consumer to resolve the problem. We can refer consumers to other places if we don't have the legal authority to resolve the matter. If health examiners are unable to effectuate an outcome that we believe is appropriate, it can be referred to the legal unit. Next slide, please. Here are some things that OCI can't do during this complaint process. We don't act as lawyers or give legal advice. We don't generally have the ability to make medical judgments or determine medical necessity. We can't act as an adjuster on claims amount, value, compensable loss. We obviously can't address issues that fall outside our jurisdiction. And we don't really advocate for any party, which is an important point. Any referral to the legal unit does not create an attorney-client situation. Rather, OCI is interested in enforcing Wisconsin's insurance laws against regulated entities, as neutral regulators. Next slide, please. Finally, I would encourage you to check out some OCI resources, policy form checklists, bulletins. We have lots of publications directed at intermediaries and also at consumers. Wiscover.com obviously is a great resource, and we put out Wisconsin insurance reports. Thank you very much.
Awesome. Thank you all so much. We will have a brief Q&A if anyone wants to put some questions in the chat for Shelly and Sharone to either answer live or to take back to their organization. We have one question that says, a certified application counselor cannot assist with Medicare enrollment. Is that correct? They need to be referred to ADRC or SHIP. What about other types of clinical staff, like community health workers, social workers, clinical staff, etc.?
Well, I can take a crack at this, but this is a little bit out of my wheelhouse. I believe the general answer is yes, but as to what other types of clinic staff, that's kind of a nuanced question that I've actually been working with covering Wisconsin on. So I don't have like one answer, but perhaps I could get the contact information and follow up with you individually.
Perfect. Do we have any other questions before our break and then resume at 11 o'clock? We'll give it another minute or so people can type in if they are typing.